uncertainty, the
Let's
markets
get
all
started with
confused.
our next session. Trying to stay on schedule because after all, we all work in the construction industry and schedule drives everything. So we'll try to keep this program on schedule. This next session is discovering and dealing with liability issues. The big four up here are Kim Severson, who is a tax partner, Eric Ruzicka, who's in our construction litigation practice group, Ryan Mick, who's in our employment and labor group, Mark Kaster, who knows everything about all things regulatory, and with the Trump administration getting rid of all regulations, will not have a job anymore. So, take it away.
We were just discussing how long the Trump administration will be the Trump administration up here. We weren't sure. So a lot of uncertainty in the world, obviously. You know, at the beginning of the day, Jocelyn mentioned that unlike some of our seminars that we've done that are heavy on change orders and claims, that today was more of a bright and cheery day about M&A and looking into growth of your company. And in any good movie or book, there's always this arc, and you need the dark period in it to make the whole thing work. And I guess we're the dark period because we're going to be talking about liability and risk. You know, and in any acquisition, identifying, assessing, and accounting for that risk is what's critical. It's always going to be there, and you just need to be able to sort of understand it, figure out how to assess it, and account for it properly. And, you know, I'm in the construction litigation group here at Dorsey and Whitney, and so I'll talk a little bit about it specifically from the construction standpoint. But we wanted to spend the next 45 minutes talking about those risks that are not just in the traditional construction context, but also in three areas that we think commonly drive risk in these areas: the tax area, the human resource area, and the environmental area. So, brief introduction of myself. I said I've been here about 15 years in the construction litigation group, practiced primarily in the construction world and the commercial real estate world, and I'll let everyone else introduce themselves quickly.
So my name is Kim Severson. I'm a partner in our tax group here at Dorsey. I've been here 18 years. While I do a lot of different things in the tax area, I am primarily a transactional tax lawyer, and historically most of my work has been in the M&A transactional area.
My name is Ryan Mick. I've been in Dorsey's labor and employment group for about 15 years. My practice spans the gamut of employment-related issues. About 50% of it is advising employers, and I'd include in that M&A deals. And then the other half is litigation. So when employers don't listen to me the first time, then I'm happy to help defend them when things go bad.
Good morning, and I'm Mark Kaster. I'm a partner in our regulatory affairs group. I've had the good fortune of being at Dorsey for 35 years and practiced at the very beginning of environmental law as it came into fruition back in the early 80s, and I've kind of grown up with it since then. And so I work very closely with my colleagues here, our real estate group, our corporate group, and all aspects of environmental health and safety issues.
Sound like you've been here before the environment even, Mark.
It's true.
So we're going to talk first about identifying risk. You know, what are the triggers to risk that you should be looking for? And we've set this up sort of more as a discussion, and you've sort of been laid out the nuts and bolts of how you do an M&A deal. We want to talk a little bit more conversationally about some of the risks and how you deal with them. So certainly as you have questions, or if there's things you've seen or things that we've mentioned that you want to talk about, jump in and we'll be happy to do it. But, you know, as Tim mentioned early on, you know, one of the reasons that we see growth and want to see growth for our companies in these areas is expanding beyond the typical range that you've got, whether it's geographic or in scope of type of projects. And what we've seen is that's also the sort of the red flag or the trigger for risk. You know, when we see companies expand out of their typical range of expertise on the construction side, we see risk start to occur. And, you know, think of, you know, a company perhaps that builds, you know, their sort of bread and butter is industrial or shopping centers or something of that nature, and they want to expand, and all of a sudden they've acquired somebody who's doing more vertical work and maybe condo development. Well, initially you might expect that the company that you've acquired has got, its own project managers and budget teams and estimating groups that have done that. But it doesn't take too long before you start to get some cross-pollination. And, every one of your companies has sort of the cleaner project manager, right, that goes to the problem project. And those new projects that are outside of your typical area have different challenges. Those industrial parks might not ever have partial occupancy, and now all of a sudden they're in a condo building that's got some partial occupancy challenges, and those can be huge challenges as you move forward. And dealing with sort of a condo owner can be very different than dealing with the industrial park owners. So as you go into different areas, you're going to have to assess that risk differently. That can be true for the delivery methods as well, as Tim mentioned. If you're typically more of a design-build entity, and now you're expand the delivery methods that you can go after, but you're getting into some P3 areas, there might be some risks there as your estimating teams aren't quite used to some of the challenges that you see in those areas. So those are some of the big things that we see sort of in the traditional construction setting, but how do each of you view risks in each of your areas? Maybe we could talk about that.
Want to start with me?
Sure.
Well, so the tax risks are typically in an M&A deal. The parties look at them in a sort of our watch, your watch setting. And what this means is that the sellers of the company or the assets are responsible for all taxes incurred or related to the period before the sale closes. And by contrast, the buyer is responsible for everything after the close. And that sounds pretty simple, and it actually is, sometimes it can be very simple. You simply evaluate what the risks are for the pre-closing period, and if you need some kind of special protection for the buyer, you build that into your purchase agreement. The more complicated situations obviously pose additional challenges, and we'll get into those a little bit later. The buyer needs to think about a couple of other things as well. One is that if the buyer's business is expanding or moving into different areas or perhaps into different geographies, the buyer needs to step back and ask what their tax costs and expenses are going to be after this acquisition. And their tax profile might be a little bit different. They might be obligated to pay taxes in a different state or locality. They might find themselves subject to different kinds of taxes. For example, maybe suddenly they owe real estate taxes that they didn't owe before. They may owe personal property taxes. And then there's other kinds of weird taxes that people tend to forget about, which is things like vehicle transfer taxes, taxes on rolling stock, which, I don't know that many construction companies have rolling stock, but there are, in fact, taxes on rolling stock. So the buyer needs to step back and say, what are my tax costs going to be after I have finished this acquisition? And you need to keep in mind that there are lots of taxes other than income taxes. And quite frankly, income tax compliance is usually pretty good, and the seller's records are pretty clean on income tax side, but that compliance may not be as good when it comes to things like sales and use taxes and property taxes.
From an employment standpoint, I thought about how to categorize things, and I think at a high level, there's two areas of risk that I think about when I'm looking at a deal on the buyer side. The seller side is a little bit easier. On the buyer side, it's is the personnel issue, your key employees. You think about what are you buying? Obviously, you're buying assets, you're buying property, but oftentimes, as much as anything, you're buying people. You're buying the critical information that's in their heads. You're buying the relationships that they have formed that you want to take advantage of. So how are you going to handle the risks associated with those individuals? Are you going to be able to establish some retention measures to ensure they stay in the near term and in the long term? Are you going to develop some post-employment restrictions if they do happen to leave at some point to make sure that they can't take advantage of that critical information and those relationships that they've formed that you're now trying to take advantage of by competing against you? Make sure you think about things like existing change of control provisions. Are you going to have severance obligations simply by virtue of the fact that you're doing this deal as a buyer that you might have to deal with either in terms of the purchase price or actually dealing with after the fact? So I think one of the key risks is, areas of risk is dealing with the personnel. Then the second broad category would be compliance and claims, the sorts of things that you deal with in your representations and warranties. Let me just mention, again, in the interest of time, I'll keep these very high level, but a few issues that I've found to be particularly significant in this context, the construction context. And again, just issue spotting with you all here, and happy to talk about that in more depth later on. Union issues. Make sure you have a full understanding of the collective bargaining agreements that might be in place. If you don't have CBAs in place, have there been organization efforts that you might see recurring over time? Have there been work stoppages and strikes? Are there unfair labor practices issues going on? You want to make sure as part of the due diligence that you're fully on top of those. The second broad category is immigration. Immigration from an agency standpoint has been a hot topic. Certainly in the context of the Trump administration, it continues to be. But in this industry, I think immigration compliance has been a big issue. The third one, wage and hour compliance. For those of you who follow the Department of Labor and its recent strategic enforcement initiative, wage and hour compliance has been a big deal, and the construction industry in particular has been a target of that. So in terms of the people you're buying, you want to make sure that you are buying something where they are in compliance with the various wage and hour obligations that they had, such that as you transition, you don't have issues popping up. Closely related to that, independent contractors, another real focus of the Department of Labor. They care a lot about independent contractor misclassification, and that's something that you really have to dig into, because oftentimes the people that you might be talking to on the sales side don't really know the independent contractors that are being engaged. So it's something that you really have to dig into, and then make sure that the classification process has been appropriately handled. One other issue, and it's kind of a non-traditional risk, but I think it's very important to mention because it can have much longer implications than, say, an FMLA claim or a workers' compensation claim and the like. And that is the risk associated with not handling the operational transition well. And so that's things like making sure that personnel files are transitioned appropriately, that employees understand who's their employer before and who's their employer now. Benefits issues like Tim talked about. Make sure that you have your plans in place, that you know what's going to transition, what's not going to transition. Make sure your payroll's ready. You don't want to be caught without a payroll process ready to go when you start taking over operations. Do you have employees on leaves or performance improvement plans? Those are the sorts of things that might not result in a claim per se, but can have a really significant impact on the combined culture going forward if it's not handled correctly. So it's a non-traditional risk, but one that can have very significant long-term impacts.
We could spend an entire session on environmental diligence, but let me share with you some key thoughts. The purpose or objective of environmental diligence is to answer really one key question. Are there recognized environmental conditions on, in, at, under, to, or from the property at which involved in your transaction? The diligence can be adjusted and can be more or less robust, but we're always trying to answer that key question. Are there environmental conditions, whether they're current conditions, controlled conditions, historic conditions? We want to know what the state of the environmental impacts are on the property you're involved in. And the reason the diligence often focuses extensively on environmental matters is that the potential liabilities can far exceed at times the value of the deal. So the liabilities can be applied strictly without regard to fault. If you're an owner or operator of property, you can have environmental liability exposure. If you ignore or exacerbate conditions on property, you can have environmental liability exposure. If you do something seemingly innocuous, like purchasing property at a discount, you can have an unintended consequence of liability, environmental liability exposure. If there was ever a reason to follow the admonition caveat emptor, let the buyer beware, it's because of environmental liabilities. They can be very significant, and so it's a very significant and important part of the diligence process. It typically starts with a phase one, but it can quickly morph into something much broader than a phase one. You can look at compliance, you can look at asbestos issues, you can look at solvents, transformers, sumps, waste piles. The list goes on and on. Today's buzzword is vapor, soil vapor, vapor gas, vapor intrusion into buildings. I'm working on 3 sites right now where clients have hundreds of thousands of dollars of unexpected costs due to vapor intrusion, things that 5 years ago nobody really thought about. Today, those old issues, those legacy issues are coming back, and they're really affecting the bottom line, the balance sheet. During the 35 years I've been practicing, each year seemingly brings some new environmental issue. And I don't want to leave you with the impression that these can't be managed. They can be. The fact is there are a lot of tools and things that can be done to help you assess and then to manage that risk. And part of what we'd like to convey today is environmental risks are not deal killers. They can be managed. You just have to be able to address them, evaluate them, and then move forward in trying to figure out how you're going to manage them going forward.
So one of the obvious, I think, things to keep in mind is doing your due diligence as early as possible. How about outside vendors for each of you? In your areas, do you typically engage outside vendors to help with this due diligence, or is it something that between you and the client can be handled?
So in the tax area, it really varies depending on the nature of the deal and the size of the deal, I think it's fair to say. It also depends on what kind of resources both the buyer and the seller have in-house. So very small company, and often larger companies don't have in-house tax people. They rely on outside vendors for their tax preparation and the ongoing compliance on tax issues. So I think it's fairly typical. We see a whole range of things in terms of tax diligence. Sometimes a buyer will buy assets solely, and I think you probably all understood from Robert and John's presentation that an asset purchase in general from a tax perspective is going to expose the buyer to somewhat fewer liabilities than a stock purchase or some other kind of equity purchase. So in an asset purchase, it's not uncommon to see relatively little diligence on the tax side, maybe done by in-house people. Somebody might do a search for liens. I would hope they'd do a search for liens. The lawyers would typically do that. But once you get into more complicated deals, particularly stock purchases, and I would say particularly the purchase of stock from a family-owned company or other privately owned company that has a long history, maybe it's an S corporation, in that case you'll see a lot more intensive diligence. That diligence may be done in part by the law firm. For example, we at Dorsey often do S corporation tax diligence because often that implicates the terms of trusts and other kinds of substantive legal issues related to the shareholders of the S corporation. Taking it one step further, in larger deals, the buyer may engage an outside accounting firm to do the tax diligence. And in that case, you may see very comprehensive review of everything from the employment taxes and sales and use taxes to income tax returns filed in multiple jurisdictions and sometimes even foreign jurisdictions. That will produce a comprehensive and usually very conservative tax diligence report. So you really do see the gamut, and in evaluating a deal as a buyer, you have to determine upfront what kind of level of diligence do you think this deal merits, and start that very early, because nobody wants to hear about a substantive sales and use tax issue with a $14 million liability about 2 weeks before you're supposed to close the deal. That's not popular, but it happens.
Mark and Ryan, how about outside vendors in your worlds?
I can answer pretty quickly. Almost never. In the HR world, so much of it is inside knowledge about the organization, both that might be acquired and the acquiring organization, and how you integrate those issues. Certainly there are the legal issues that I can assist with and do, but so much of it, that every organization, regardless of size, has somebody who's in charge of HR and knows the employees, whether that's a CFO that just happens to be assigned to the HR function or an existing VP of HR. There's someone internally, usually on both sides, that knows that stuff better than an outside expert could possibly do. And so it's usually, in my case, me working with the HR representatives inside. And because of that, let me bring us back to the first bullet point here before I hand it off to Mark. It's really important to conduct this diligence and start that planning really early, because your VP of HR is going to have their ordinary responsibilities, and you're going to be layering all of this additional stuff on top of it. So in terms of planning from a cultural and integration standpoint, really important to give your HR people a break by planning and working on this stuff really early.
Mark, the question is probably how many outside vendors?
I can answer this quickly too, always.
Yeah.
We work very closely with environmental consulting and engineering firms, many of which are in the audience here today. And it's a very important part of the interaction, helping clients get to understanding the risks and then determining how to manage and mitigate those risks. And one of the key benefits, I think, of working with counsel in these relationships is the attorney-client privilege. We can't protect the facts. They are going to be what they are. But our discussions around those facts, our advice around the facts, the back and forth that we have in terms of evaluating what to do, how to do it, when to do it, whether there are reporting requirements, how to get involved with agencies, all of these strategic questions are significant in terms of the interaction between the client, both a buyer and a seller, perhaps even a lender, and then the relationship with counsel and outside consultants. And so managing that process, protecting what can be protected in terms of privilege is a very key element, and one that we take very seriously, and we found really good partners with the consulting community, both here in the Twin Cities and of course we work all around the country. Those relationships are very helpful because it's not like we're coming to the client and to the consultants blind. We tend to have those deep and long-standing relationships, and it's very helpful in terms of ultimately getting to your objective, which isn't to kill the deal, but it's to figure out how to manage the risk and move the deal to a successful close.
So I have a question for Mark and Ryan. We often, from a tax perspective, we have kind of a standard form diligence checklist. And often sellers will ask to see that many months before putting themselves up for sale, because they can look at that list and they can see, okay, these are the sorts of things that I'm going to be asked. What can I do now to prepare myself? I can start gathering documents. I can maybe clean some things up. I can talk to people. Do you do that sort of thing? And do you see sellers sort of prepping themselves for sale?
Absolutely. One of the slides to come, and you have a laminate handout in your packet, is a flow chart that I put together a couple of years ago. I often get the question, what does environmental diligence look like? How much does it cost? How long does it take? How much confidence can I have in the results? Fortunately, you don't have to read this small print on the slide. You do have the laminate in front of you. But what we've tried to do is take this and make it a process for clients to understand, how do we get from the beginning of a transaction, which oftentimes does start prior to the actual deal itself, to the end of that slide or the laminate folder that you have. And so we take that and move that through the process, and I think it's a very helpful flow chart in terms of an understanding of how the environmental diligence goes forward. And then on the right-hand side of that flow chart, we have what the typical timing would be and what the typical costs would be. And so with that, you really do have a solid understanding of how we move through the diligence process and how we get you to a successful closing, and what the options and the key decision points are as you move through the evaluation of environmental issues. So hopefully you'll find the spreadsheet there very helpful.
Yeah, and if you talk really nicely to Mark, he'll give it to you in a big version, which it is a fantastic tool to sort of, I mean, his is in the context of the environmental world, but even just for any of the issues that we've talked about, just sort of thinking through from start of transaction to closing and even after, how you think through that from a sequence, and sometimes it's helpful to get it in that flow chart.
Well, and I got the question asked so many times from clients that it just made sense to try to put this into an orderly process. Where do I start? What are the inputs? What are the outputs? And where do I have key decision points? And so the flow chart really does take you through the entire process and gives you a variety of options, from everything from, we're going to can the deal to how do we manage the risk. And we're going to talk in a minute about the options and tools for managing the risk.
Yeah, so we're sort of transitioned, and none of this stuff is completely linear, but about evaluating the risk. And from my experience on sort of the more straightforward construction perspective, I think of pending risk and potential risk, and that pending risk is more clearly those pending litigations that are out there of the company you may be acquiring. And those are frankly a little easier to evaluate, depending on where in the litigation it is. You've got discovery, you've got specifically stated claims. You can look at that a little bit more clearly. You still need to be careful about it because there may be things that aren't quite clear on the reports that you're getting, but a little easier to look at. On the potential risk side, I think of those as the projects that are out there still that are potential litigation down the road potentially. And that's much more difficult. First, you have to decide, and we heard this from Robert and John earlier on how much due diligence to do and where to cut that off. You have to figure out, do you evaluate all the projects? That's probably not realistic. You may immediately gravitate just looking at the bigger projects, but it's important that not quite be the only test. Small projects can have significant consequences. I was just dealing with a case that looked to be a very small project, but then there happened to be a False Claims Act component lurking in the project after the acquisition that nobody realized existed. So while it was a small project, that False Claims Act component was very significant and had serious consequences potentially for the company. Larger contracts obviously probably warrant more looking at, and sometimes there can be hidden complexity there as well. Think of something just as simple as a GMP concept. We've been talking internally about one project that was a GMP, and you really need to look at the details. This one had the GMP included 1 month of crane usage, and this project wasn't in the local area, but it had a giant crane similar to the very largest crane that was brought in to construct the new football stadium over there. And when you started to look at the schedule and the crane usage, it became clear that 1 year maybe wasn't going to cut it. And if you got past that year, the risk of this really significant crane and where that cost shifted was a significant evaluation of this contract. So digging into the contracts and the details of them is very important when you start to evaluate risks on the construction side. Ryan, we'll stay there, on the labor and employment side, how do you sort of begin to evaluate those risks that you're seeing?
Yeah, and I kind of like the dichotomy between pending and potential. Usually the notion of pending risks, that is the outstanding claims and the like, isn't the significant driving issue on the employment side. Either you're not going to have outstanding claims, or if you do, you understand that they're, in the context of the entire deal, relatively low value, maybe not material at all. And we have, in this context, oftentimes a structure that at least provides a framework to have a rational discussion about where those risks are going to lie. And we've talked about asset versus stock sale, for example. Asset sales, typically those liabilities, those claims aren't going to continue unless they're reassigned. Stock sale, typically they are. And so you have this structure where you can analyze the pending claims if they're material. Much more significant in my world is the notion of potential claims. And that gets back to some of the things I mentioned earlier. Key employees, are you potentially going to lose someone? How do you retain them? What are the risks of that information, those relationships walking out the door? In terms of prioritizing, which I think is really critical on the employee side. Listen, employment issues typically aren't going to be the things that blow up a deal. So you're typically going to have your employment issues being the tail that you don't want to wag the dog. And so what you want to do is you want to focus on the key potential issues. And again, that would be your key employees. How are you going to retain them? And I'd say the second one would be protecting your confidential information in those customer relationships. Do you have the proper non-disclosure and non-compete and non-solicitation obligations in place? And if not, how do you get there? So I think those are the top two, and you could talk about things like unionization issues, making sure you understand that, because oftentimes there's not much you can do, particularly in the context of a stock sale or a substantial continuation of business. If you want to complete that deal, you're going to be stuck with any existing union that might be there. And then things like I talked about in terms of the post-closing obligations and post-closing operations and making sure those things are set. But it really is, in the employment side, I think, a much more significant focus on the potential issues, again, maintaining those key employees and maintaining the information and relationships you're buying, and doing that in a prioritization sort of way.
I think the process of evaluating environmental risk has a lot of moving parts. the buyer wants to evaluate structure as an asset deal, is it a stock deal? There might be financing considerations, there might be materiality issues. It often comes, it's true that, you know, a large deal might be easier to manage the environmental risk than a small deal. And I say that because the liability exposures, you know, are the same. The materiality thresholds might be very different. A lender might be involved in a transaction, and the lender might have its own set of environmental requirements. Are they taking a mortgage on the property? Is it a, you know, an asset acquisition in which the property is pledged in some way? The sellers, their view is we want to walk away. We don't want to have a skeleton in the closet. How are we going to manage whatever's found in this diligence process? We want to keep that diligence process as narrow as possible. We don't want Pandora's box, and we don't want to have the concerns of an unknown. We bring consultants to the site to carry out both kick the tire evaluations and more invasive evaluations in terms of phase 1 and phase 2 reports. We often interface with agencies to help evaluate the risk. And we can use the tools that are out there from the agencies in getting their written assurance letters. Minnesota has a fantastic program for helping companies take property that does have an environmental impact and moving it from impact to back into some kind of productive use. Different states around the country don't have those same kind of programs. In fact, some are much more draconian, like in New Jersey, where you've got a property transfer requirement which requires you not only to evaluate, but to potentially fix industrial sites that have environmental problems. So you really have to have an understanding in evaluating the risk of all the sort of 5 W's, the who, what, when, where, and why issues in terms of the environmental constraints that might be present with respect to not only the transaction, but the actual conditions on the property. And one of the things that I guess I find very important is a lot of times clients will want to make the evaluation on the front end, and they ignore the exit strategy. So it's okay to do your evaluation and go through your diligence process and try to manage that risk and perhaps even take that risk, but you may flip that property, or you may move, or there may be a transaction in your future 3, 4, 5 years down the road. And so, you know, it's kind of the pay me now or pay me later issue. You want to try to address those environmental risks right up front and find a workable solution so that you can then play that forward in your exit strategy or in the next transaction that comes down, and you've now dealt with the issue, you've already internalized it, the costs are already dealt with, and you have a better opportunity of being successful both on the side of the deal as it goes forward, and then on the exit strategy when you move on to the next.
So on the tax side, evaluating the risk is going to depend in large part on what the structure of your deal is. So if you've got an asset purchase or sale and it's relatively straightforward, you may not see very much in your diligence. You may not really care. You may search for liens and do a little bit of other diligence, and the buyer may be comfortable moving on. Now, in that context, it's you know, in an asset purchase, what are you looking for? Well, you're not taking on the liabilities in general of the selling corporate entity or LLC, or at least you hope you're not taking on those liabilities, and I'll come back to that. So you may be looking to see if there is an ongoing, perhaps, property reassessment for purposes of personal real property taxes, and that would be a pending risk in an asset sale. But you're not really generally looking at the seller's federal or state income tax returns because you're not acquiring that entity. So that's that sets up one sort of posture. By contrast, if you are buying the stock of an entity, whether it's a C corporation or an S corporation or potentially even an LLC, you need to look at whether there are pending assessments against that entity. And those assessments could be of income tax, sales and use tax, employment taxes, property taxes. Once you've identified any pending assessments, you have to figure out what the size of those potential risks are, and you need to protect yourself in some way. Now, to take a very sort of concrete example that comes from something Ryan said, is say this particular entity has a significant number of workers who have been classified as independent contractors, not employees. That has very significant potential tax consequences. It may have Department of Labor and other consequences, but it's got tax consequences. And if you're taking on those employees, you need to evaluate whether that classification of those individuals as independent contractors was correct for all the pre-closing periods. Because if it's not correct for the pre-closing periods, you could potentially end up being liable for all of the employment taxes that were not collected with respect to those people. And you could be liable for significant penalties for failure to report things on W-2s and other kinds of information reporting. So those exposures could be pretty significant in the pre-closing period. But that issue also has consequences for the post-closing period, because if you keep those people and they think and you think that they're going to continue to be treated as independent contractors, and that is not correct, you are perpetuating that exposure into the post-closing period. And that can be really quite significant. It also can change the way those individuals feel about you as an employer. If they've been used to getting their payments on a 1099 with no Medicare, Social Security, and income tax withholding, this kind of changes what they look like. Also, if you're operating in a partnership and you make them employees, but they also happen to be equity owners because they're senior management, that's a whole another area of exposure and consideration. So many of these issues will kind of transcend the bright line of closing and infect the post-closing period. So you really need to understand how they affect both your liability for pre-closing taxes and what it makes your organization look like in the post-closing period. One other thing I'd just like to say is that even in a simple asset sale, there are state tax laws that impose the state taxes of various sorts on the buyers, even though you don't buy the interest in the entity. So you need to be extremely careful about that and make sure you've evaluated that.
So we've sort of segued into, I think, mitigating the risk by some of the things you were just talking about, Kim. And when I think of mitigating the risk, and Tim alluded to this at the beginning of the day, I think one of the main purposes of these acquisitions is often the people. And so, I mean, this segues to what you were saying earlier, Ryan, as well. And from my world, if you're litigating a case that's sort of a legacy case of a company that you acquired, I did this just recently, where everyone that worked there that was on the project is no longer with the company. That's really difficult to do if people won't return your calls anymore, or they won't sit down with you to prepare for a deposition because they're off in their new world. That's a scary environment to litigate in, let alone to run your projects in. So from mitigating that risk on the employment side, what can you do?
Yeah. And just to reiterate some themes, a lot of it depends, again, on the structure of the deal, how many of those liabilities you might be incurring. And of course, even if you're in the context of a stock sale, if there's pre-existing litigation, you can try to assign that liability back to the seller. It's just all part of the deal. In the context, but that's pending claims, and again, pending risks. And again, I want to, in the very limited time I have, really go back to what I think is the more important thing for employers to consider in the full scope of these deals, and that's the potential risks and how you mitigate those. Again, the potential risks are things that, other than the claims that might be coming up in the future. You know, in the employment universe, we have what I think is a much more significant opportunity for self-help than in the environmental situation, for example. I mean, if there's an environmental issue, it's there no matter what. If we're talking about key employees or the protection of confidential information, even if the seller, if you're on the buy side, doesn't have things in place, you have quite a bit of leverage in the context of the sale to require that those things be put into place. You can require retention agreements. You can require your key employees to enter into non-compete and non-disclosure and non-solicitation agreements. And the courts are going to be very favorable towards those, generally speaking, in the context of a purchase, much more so than in other contexts, for example. So don't lose sight of the fact that you have a lot of opportunity to create the universe in terms of key employee retention and the protection of relationships and confidential information that you might not have in the tax or the environmental side. Beyond that, I think the list that we have here is a pretty good list of the things that I look for in terms of dealing with the pending claims or the possibility of claims. Representations and warranties are significant. Don't let me walk out of here without emphasizing the importance of really having specific representations to the extent possible. Just as one example, it's an entirely different ballgame if the representation is we complied with wage and hour laws, as opposed to making the seller think about specific issues by asking for specific representations. We recorded time for our non-exempt employees correctly. We classified independent contractors correctly, to Kim's point. We classified our exempt employees correctly. We maintained insurance as we were required to for purposes of unemployment or workers' compensation. We complied with immigration. I mean, if you just say general compliance, you're not going to get into those things. And as often as not, you simply having the opportunity to identify and raise issues that might have otherwise slipped by is as important as anything. Indemnity and insurance, very important. Make sure that your acquisition had maintained insurance for those sorts of pre-closing claims. Adjustments of purchase price and covenants requiring seller to fix, we use those from time to time. But I think this is a good list in the interest of time.
So Mark, what do you think of adjustments to purchase price?
Don't do it. My goal is to move you from understanding the environmental risk to an allocation of that risk to meet your business needs. As I said before, it's pretty easy to kill a deal, but that's not your objective. It's how do I manage this risk? And we use all of the tools that you see up here and more. There are a number of agency programs that can help manage risk. I just finished up a deal in Michigan. Michigan has a specific helpful law that allows you to file some paperwork creating a baseline of the environmental conditions, and with that baseline you can avoid some liabilities going forward. Minnesota has great programs as well to, on a voluntary basis to get written assurance letters that say if you go and undertake certain activities at the property, you're not going to be exposed to environmental liability from an agency perspective going forward. So, I think understanding where the risks are, understanding how to manage them, and then allocate them in a fashion that meets your business needs, both buyer and seller, coming to some common ground using any number of these type of techniques, whether it's indemnity, caps on exposure, deductibles, escrows, post-closing agreements, insurance programs. All of these things I think can be used. And one of the great things that I think we do and add to business transactions is in a cooperative fashion. We're very closely with our corporate colleagues and those running the deals to come up with hopefully some very creative but solutions that work, solutions that help you manage the risk. And in the environmental area, as I said before, those risks can be very significant. Even on small deals, they can overwhelm a deal as opposed to larger deals where perhaps at times it's more easy to or it's easier to manage those risks.
So from the tax perspective, very quickly, I think my perspective is a little bit different than Mark's. I mean, typically it is pretty unusual to have a tax risk in an acquisition that is so large that it kills the deal. We are usually able to find some kind of mechanism to protect the buyer adequately from pre-closing tax exposures, but in the most egregious cases, it may require a special tax escrow, sometimes quite large, that will roll off as the tax years close under the statute of limitations. And that could take 6 or 7 years for those statutes to roll off in particular cases. So that is a kind of a really a far-reaching way of dealing with a significant tax liability. Often what we find is that the tax liabilities seem to be adequately protected through the existing indemnity, escrow, or holdback. However, if you are doing an as-is sort of deal with no indemnification and no holdbacks, you could very well, as a buyer, find yourself eating the tax liabilities of the person that's selling to you, which is not an attractive prospect for most buyers.
All right, well, I know Jocelyn is lurking, which means there's another fascinating panel to come, and I don't want to take the risk of Jocelyn pouncing on us up here. But thank you, and feel free to follow up with us with any questions you may have. We'll be around for the rest of the day.
Thank you.
Thank you.